The Supreme Court confirmation hearing was proceeding exactly as expected until Representative Jasmine Crockett asked a single question that made Judge Amy Coney Barrett freeze, sending shockwaves through the chamber and potentially altering how judicial nominees engage with Congress forever. That morning, in room 216 of the Hart Senate Office Building in Washington, D.C., the atmosphere was tense but routine. Senators seated in a semicircle, cameras rolling, journalists alert, and Judge Barrett composed at the witness table, her expression controlled and confident after days of intense questioning. Enter Congresswoman Crockett, carrying only a slim manila folder, noticeably more minimalist than her binder-laden colleagues. When her turn came, she approached the mic and stated calmly, "Judge Barrett, I have just one line of questioning today." Barrett nodded, clearly expecting more of the same until Crockett opened the folder and read 7 words that visibly rattled the judge, freezing her mid-reach for a water glass and plunging the room into stunned silence. For days, Barrett had showcased her renowned poise, sharp legal mind, and encyclopedic recall of case law, impressing even her critics and coasting toward confirmation. But Crockett, a former trial attorney trained to read subtle tells and evasions, had been analyzing Barrett's patterns closely and spotted what others had missed. In less than 5 minutes, she managed to shake the unshakable, exposing cracks beneath Barrett's polished exterior and shifting the dynamic of the entire hearing. Judge Amy Coney Barrett had grown increasingly cautious, delivering responses that gave the illusion of transparency while offering little, real substance, carefully structured answers that met procedural norms without exposing her to significant scrutiny. Seated at the witness table, she embodied more than just her own nomination. She symbolized a pivotal transformation in the American judiciary, with long-lasting implications. Having fielded days of predictable questioning, Barrett exuded confidence, skillfully navigating inquiries with rehearsed, non-committal replies. In contrast, Congresswoman Jasmine Crockett was viewed by many as a passionate but unseasoned newcomer to the confirmation process, prompting private concerns among senior senators that her approach might be too confrontational and inadvertently cast Barrett in a sympathetic light. Unbeknownst to them, Crockett had spent nights developing a radically different strategy, eschewing partisan angles in favor of exposing overlooked inconsistencies in Barrett's judicial record. "Judge Barrett," Crockett began, "you've repeatedly claimed that you approach each case without predetermined outcomes and follow the law wherever it leads, regardless of personal belief. Is that correct?" Barrett, unfazed, nodded. "Confidently, yes, Congresswoman. I believe a judge must set aside personal views and apply the law as written." Crockett held her gaze. "And you've also said that your judicial philosophy isn't shaped by private affiliations or personal convictions?" "That's correct," Barrett answered, her voice measured and familiar. Crockett then opened her folder with deliberate intent. "In that case," she said, "I'd like to discuss a ruling that appears to contradict those statements." The tone in the room subtly shifted. While Barrett's face remained composed, attentive observers noticed her posture tense, slightly a quiet signal of rising alertness. "What I have here," Crockett continued, "hasn't yet been raised by my colleagues, but it directly challenges your claim to impartiality and your ability to separate personal conviction from judicial duty. The stakes couldn't have been clearer. This was no longer just about one nomination. It was about whether the American public had a right to know if a lifetime appointee to the nation's highest court could truly set aside personal beliefs when they came into conflict with constitutional principles. "Judge Barrett," Congresswoman Jasmine Crockett began, her voice steady in the now silent hearing room, "I'd like to direct your attention to your ruling in Williams v. Cook County Department of Corrections from 2019. Barrett gave a small nod, recognition flashing briefly in her eyes. It was a relatively obscure case that had received little attention during the confirmation process until now, when Crockett's focus suddenly made it feel pivotal. "You wrote the majority opinion in that case, affirming qualified immunity for corrections officers despite evidence of deliberate indifference to a prisoner's medical needs, correct?" "Yes, Congresswoman," Barrett replied evenly. The case turned on whether the established precedent was sufficiently clear. to overcome qualified immunity protections. Crockett nodded, flipping a page in her folder. And 6 months before that ruling, you gave a speech at the Federalist Society, where you criticized the expanding application of the deliberate indifference standard in prisoner rights cases, calling it, and I quote, judicial overreach that undermines necessary discretion for corrections officials. A subtle shift in Barrett's expression, a slight tightening around the eyes, hinted at surprise at the connection being drawn. Speeches and academic commentary are distinct from judicial rulings, Congresswoman Barrett said, her voice still composed, but now carrying a trace of caution. My ruling was based on precedent and the specific facts of that case. I understand the distinction, Crockett replied, unfazed, but I'm concerned with the timing and content alignment. She produced another document. 3 weeks before Williams came before your court, you attended a private conference on prison reform, where you were part of a panel titled Restoring Balance to Prisoner Litigation. The attendee list included representatives from the very corrections department involved in the Williams case. A low murmur spread through the hearing room. One senator leaned in to whisper to another. Barrett's attorney shifted upright in his chair. I attend many legal conferences, Congresswoman Barrett said, her voice now edged with subtle defensiveness, and I recuse myself from cases where actual conflicts exist. Did you disclose your participation in that conference before? Hearing the Williams case? Crockett asked directly. Pause followed. The C-SPAN camera zoomed in on Barrett's face, capturing a flicker of calculation in her eyes. I don't believe that conference created a conflict requiring disclosure, Barrett eventually answered. Crockett showed no reaction, but her follow-up was precisely timed. Are you aware that the organizing documents for that conference explicitly stated its goal was to develop strategies to limit the expansion of prisoner rights litigation? Barrett's right hand moved toward her water glass, but stopped halfway. I don't recall the specific language in the invitation materials, she said. Let me refresh your memory, Crockett said, nodding to an aide who projected a document onto the large screen visible to the entire room. Highlighted in yellow was the exact language Crockett had quoted alongside Judge Barrett's name. Listed as a strategic advisor to the Conference Planning Committee, a visible ripple of discomfort passed through the room. Even the committee chairman shifted uneasily. Congresswoman Crockett, we should be focusing on the nominees' judicial record, not our conference attendance, he said pointedly. Crockett nodded respectfully. With all due respect, Mr. Chairman, I am addressing the judicial record directly. The Williams ruling was issued just 3 weeks after this conference, and sections of Judge Barrett's opinion reflect the conference's stated objectives almost verbatim. She turned back to Barrett. Judge, you've testified repeatedly that your personal views do not influence your judicial decisions. Yet here we have a case where you participated in strategy discussions aimed at limiting specific types of litigation, then ruled on such a case without disclosure using reasoning that closely mirrors those strategy materials. How do you reconcile that with your sworn testimony about impartiality? For the first time, Barrett's composure, so steady throughout days of questioning, visibly wavered. Congresswoman, you're drawing connections that overlook the legal rationale behind my decision in Williams, she said. Let's explore that legal reasoning, Crockett replied, calmly flipping to another page in her folder. Because in 3 previous cases with nearly identical fact patterns, you reached the opposite conclusion when the defendants weren't corrections officers. In Rodriguez v. Chicago Memorial Hospital, for instance, you wrote that medical staff showed deliberate indifference that clearly violated established rights. Barrett's eyes narrowed slightly. This was not the familiar ideological crossfire she had prepared for, but a meticulous, evidence-based challenge to the consistency of her jurisprudence. Those cases had distinguishing factors, Congresswoman Barrett began, but Crockett gently interjected. I have the full text of all 4 rulings here, she said, holding up a set of documents. I've highlighted the fact patterns in each. Would you like to point out the specific distinctions? Because legal scholars across the political spectrum have noted that the facts are remarkably similar, except for one key difference: the institutional context of the defendant. The room had grown palpably tense. Senators who had previously been distracted, checking phones or whispering to aides, were now fully focused. Barrett's supporters on the committee looked visibly concerned, while others leaned in with sharpened interest. Judge Barrett, Crockett continued, breaking the silence when no immediate response came. I want to be absolutely clear. I'm not questioning your qualifications. I'm asking about consistency and transparency. Now, the American people deserve to know whether external influences, be they personal beliefs or institutional pressures, impact your judicial decisions, especially when relevant connections have gone undisclosed. Barrett's expression tightened. For the first time during the hearings, she appeared not just composed, but defensive. Congresswoman, I believe you're mischaracterizing both my record and the significance of attending legal conferences, which is standard practice for federal judges, she replied. If you're implying impropriety, I'm not implying anything, Crockett interjected, her tone even. I'm presenting documented facts and asking how they align with your testimony about judicial independence. These aren't abstract questions about philosophy. These are specific cases where your actions appear inconsistent with your stated approach. The committee chairman tapped his gavel. Congresswoman's time is nearly expired. Crockett gave a polite nod. Just one final question, then. She turned back to Barrett, locking eyes. Given what we've discussed, would you be willing to commit here and now to disclosing any similar conference participations or strategy sessions in the future? Should cases related to those topics come before you on the Supreme Court? It was a question that demanded a clear choice, a commitment to transparency, or an explicit refusal. Neither option was comfortable for Judge Barrett in that moment. She glanced briefly toward her counsel, then turned back to Congresswoman Crockett. Congressional oversight does not extend to dictating judicial disclosure practices beyond what is already established in law, she said, her tone suddenly cooler, edged with authority. I think you're overstepping, Congresswoman. It was the first time Barrett had directly pushed back against any questioner, subtle but unmistakable shift from the composed restraint she had maintained throughout the hearings. Rather than engage with the substance of the question, she was invoking institutional boundaries, a move that seemed designed to reassert control through formality. The committee chairman leaned forward. The nominee is right to clarify the limits of this line of questioning, he said, attempting to restore order. Crockett remained composed. With respect, Mr. Chairman, haven't asked Judge Barrett to commit to anything beyond what existing judicial ethics already require. I've simply asked whether she is willing to commit to transparency regarding potential conflicts. A yes or no question. She turned back to Barrett. Judge, your response suggests you view basic transparency as congressional overreach. That perspective in itself seems relevant to these proceedings. A flash of tension crossed Barrett's face. Congresswoman, I've maintained the highest ethical standards throughout my judicial career. Your implication otherwise is inappropriate. But that, in fact, was the response Crockett had anticipated. With deliberate calm, she reached into her folder one final time. I'm not making implications, Judge Barrett. I'm providing documented facts. She held up a paper. This is a letter signed by you and 14 other federal judges submitted to the Judicial Conference 3 years ago, in which you formally opposed expanded disclosure requirements for conference participation and affiliations with advocacy organizations. Crockett distributed copies to the committee members. In that letter, specifically argued that judges should have discretion over when affiliations might constitute a conflict of interest. You even wrote that mandated disclosures would chill judicial participation in important legal discourse. As committee members silently scanned the letter, the hearing room fell still quiet, tense, and suddenly far more consequential. My question isn't hypothetical, Crockett continued, her tone unwavering. You've actively advocated against the very transparency I'm asking about. The American people deserve to know that. What had begun as an attempted show of institutional authority by Barrett had now backfired completely. Rather than Crockett appearing to overstep, it was Barrett who seemed to be hiding behind procedural shields to avoid accountability. The American people also deserve a confirmation process that respects the separation of powers, Barrett countered, but her words landed with less authority than before, more defensive than decisive. Crockett replied calmly, the separation of powers only works when checks and balances are real. Congressional advice and consent means little if nominees can conceal relevant information. She turned to the full committee. Colleagues, this isn't about politics or judicial philosophy. Justice demands more than legal intellect. It requires integrity, impartiality, and transparency. Judge Barrett's rulings reveal a pattern of discrepancies that correlate with affiliations she hasn't disclosed. Her resistance to basic transparency should concern every one of us, regardless of party. Sensing the shift in tone, the chairman tried to restore order. The Congresswoman's time has expired. I yield back, Crockett said simply. But the impact had already landed. Barrett, who had remained composed under intense questioning about abortion, executive power, and health care, now sat visibly unsettled, her strategy of calm authority undone not by partisan rhetoric, but by documented inconsistencies she couldn't easily dismiss. In the press section, reporters were already typing up headlines. Barrett defensive when pressed on undisclosed conflicts. As Crockett returned to her seat, senators from both sides of the aisle quietly examined the documents she had circulated, whispering to one another. The chairman then called a 15-minute recess, an unscheduled break that spoke louder than any statement. In that moment, the tone of the entire hearing shifted. Barrett, once cruising toward confirmation with mechanical precision, suddenly appeared. Vulnerable not because of ideology, but because someone had punctured the illusion of unimpeachable neutrality. When the hearing resumed, Barrett returned with a restored sense of poise, but something had changed. Her answers grew more specific, less wrapped in generalities. Several senators, visibly influenced by Crockett's approach, began pressing for firmer commitments on disclosure and recusal standards. By the end of the session, Barrett had made an unprecedented promise to review and strengthen her practices. Regarding conference participation and public affiliations, concession that would never have occurred without Crockett's methodical 5-minute dismantling. Jasmine Crockett had accomplished in 5 minutes what days of standard questioning had failed to do. She broke through the polished script and partisan theater to reveal something real. How Judge Amy Coney Barrett actually approached her judicial responsibilities when no talking points could shield her. In the process, Crockett flipped the dynamic of the hearing on its head, making the nominee visibly regret trying to deflect through institutional authority rather than engage with substance. More than just a sharp exchange, it became a cultural moment. Within an hour, video clips of the confrontation flooded social media. Hashtags like #CrockettQuestions and #DarthBarrettDisclosure were trending nationwide. The 5-minute segment was being dissected in legal blogs, analyzed in law school classrooms, and replayed on major news networks. CNN led with Crockett confronts Barrett on undisclosed conflicts, while Fox News framed it as Barrett commits to review disclosure practices after tough questioning. MSNBC's headline read, Crockett exposes pattern of inconsistency in Barrett rulings. What made the moment so compelling wasn't its partisan impact. It was the substance of the challenge and Barrett's uncharacteristic discomfort when confronted with documented inconsistencies. Not hypothetical. In the Senate cloakroom conversations, buzzed across party lines, she came with receipts. One senior Republican senator was overheard saying, "It's not political talking point, it's actual evidence." A Democratic senator, who had spent his allotted time grilling Barrett on broad hypotheticals about abortion, admitted to his staff, Crockett did more in 5 minutes with case law than most of us did in 30. Legal experts from across the spectrum chimed in during the evening broadcasts. On CNN, a conservative scholar noted Crockett's effectiveness stemmed from her refusal to frame the issue. Ideologically, she focused instead on judicial process and consistency. Values that transcend party lines. Even a liberal commentator on Fox News conceded this wasn't a partisan gotcha, these were fair, evidence-based questions about transparency and judicial integrity that any nominee should be ready to answer. At the White House, advisors scrambled to assess the damage. While Barrett's confirmation still seemed likely, the administration now faced a challenge they hadn't anticipated, a credibility issue. It's not just with the opposition, but with the broader public. After internal debate, they arranged for Barrett to submit supplemental written responses, specifically addressing the cases Crockett had highlighted in an effort to explain the discrepancies and blunt the narrative that had taken hold. Meanwhile, back in her congressional office, Jasmine Crockett found herself suddenly in high demand. Interview requests flooded in, senators from both parties sought meetings, and constitutional law professors invited her to speak to their classes on the art of effective oversight. When a reporter asked why her approach had differed so sharply from that of her colleagues, Crockett's answer was simple and direct. "I'm a former trial attorney, Brett. I don't ask questions unless I already know the answers and have the documentation to support them." This wasn't about scoring political points. It was about making sure the public gets the full picture on someone being entrusted with lifetime power. The broader impact was felt quickly across Washington. Other judicial nominees began requesting additional prep time ahead of their confirmation hearings. Senate committee staff started digging deeper into nominees' conference appearances and affiliations that hadn't previously raised red flags. Law firms that specialized in preparing nominees quietly revised their protocols, placing new emphasis on identifying and addressing any discrepancies between public statements and judicial records. Just 3 days after the Barrett hearing, the Judicial Conference announced a formal review of its disclosure requirements for federal judges specifically. Whether participation in issue-focused conferences should trigger mandatory transparency. While the statement didn't mention Barrett by name, the timing made the motivation clear. Editorial boards from the Wall Street Journal to the Washington Post weighed in, calling for more robust disclosure standards in the judiciary. A rare consensus emerged across ideological lines. Judicial independence must be preserved. But transparency about potential conflicts strengthens rather than threatens the credibility of the courts. In law schools across the country, the Crockett-Barrett exchange was quickly added to syllabi in courses on congressional oversight, judicial ethics, and legal advocacy. Professors praised Crockett for modeling the difference between asking someone what they believe and holding them accountable for what they've actually done. The week following Jasmine Crockett's powerful exchange with Judge Amy Coney Barrett revealed a rare shift in both public opinion and institutional behavior. While partisan divides over Barrett's nomination remained, an overwhelming 87% of Americans across the political spectrum agreed that Supreme Court nominees should be required to disclose participation in conferences and advocacy events related to their rulings. Crockett's fact-based, methodical approach cut through the ideological theater that often defines confirmation hearings, exposing not just inconsistencies in Barrett's record, but the broader lack of transparency. In the judicial vetting process, Barrett, recognizing the weight of the scrutiny, submitted supplemental written responses, defending her rulings, but also acknowledging that undisclosed affiliations could raise legitimate concerns committing standards going forward. The ripple effects were immediate. Senate staffers began digging deeper into nominees' affiliations. Legal prep teams rewrote their protocols, and even the Judicial Conference initiated a review of its disclosure requirements. Crockett's approach rooted in evidence, not ideology, inspired lawmakers from both parties to rethink their questioning strategies. And within months, a noticeable shift occurred in how Senate committees conducted oversight. Fewer hypotheticals, more documented case analysis, and less partisan posturing. A year later, Crockett authored a chapter in a legal textbook on effective congressional oversight, arguing that accountability isn't about attacking beliefs, but testing whether someone's actions align with their stated principles. Her 5-minute exchange didn't just reveal flaws in one nomination, fundamentally raised the bar for what transparency and consistency should look like. From nominees entrusted with lifetime power